Well, thank you very much, everyone, for coming to our Innovative Discovery series. We are very excited today to have Dr. Rolnick from University of Pennsylvania and the Philadelphia VA to give us a talk on law, technology, and end-of-life planning. But before I introduce him, let me mention some housekeeping issues. So as you know, for CME credit, you must sign in and you must include your email and credentials. Don't miss our February 7th and February 8th Tech Talks. So February 7th, we'll have Erin Crowgy from Nemours, who will be speaking on the promise of precision medicine. And then February 8th, we'll have Dr. Lorenzo from University of Delaware. So we have 2 Tech Talks in February. Also, please note that on January 11th, we'll have another ID series, and we will have a special guest, Dr. Tara Lagou from Bay State Health, speaking on beyond rants, raves, and reputation, using patient comments to improve care. That's going to be super interesting. So please register to help us prepare. And as usual, the full schedule is posted on our website, DE-CTR. So I'm really excited here to introduce Dr. Rolnick. Dr. Rolnick is a physician in the Philadelphia VA Medical Center. He's also an advanced fellow in the Department of Veterans Affairs, an adjunct lecturer at the University of Pennsylvania Law School, and an associate fellow at the Leonard Davis Institute of Health Economics at University of Pennsylvania. He got his MD from Stanford University School of Medicine, as well as a JD from Yale. And recently, in 2018, he got also a Master of Science in Health Policy Research from University of Pennsylvania. Since 2016, he has been working in the Center for Healthcare Innovation at University of Pennsylvania, where he is a core member in the multidisciplinary team that created EHR-integrated web platform for advanced directives. He has also numerous projects in the Department of Medical Ethics and Health Policy at Penn. He has received multiple awards and has already several first author peer review publications, including one last year as first author in the New England Journal of Medicine. So thank you very much, and we look forward to hearing your talk.
Well, thank you very much. I'm very happy to be here and share some of the work that we've been doing at Penn related to end-of-life planning and technology. Just a disclosure, I'm a consultant from time to time for a data analytics company called Trouble Health. So I'm going to, oh, yes. I'm going to be talking a great deal today about advanced directives and end-of-life planning, and I'm going to start by discussing the legal origins of advanced directives, and I'm going to connect that to how they're used today and to how technology is now being used to try to reinvent documenting end-of-life plans. I suspect the beginning will have more law than many of these talks do, but that's by design. I think it'll provide a bit of a different but informative perspective on these issues. So first, what is an advanced directive? And an advanced directive in the law is one or both of 2 separate types of documents. The first is a living will, and that's a document that has information about a patient's preferences for their medical care, their instructions for care. And then a second document, a healthcare power of attorney, that has the person or people that the patient would want to make decisions for them if they're unable to make their own decision. And together, those are an advanced directive. And just as a note that often these documents, particularly living will, they often may not be available or may not be used, but they can be one of the only sources of information that comes directly from the patient. A lot of what we use is in the medical record, is sort of the product of conversations with patients and families, and that's very valuable, but this can give a direct voice to the patient. So this is an example of one of the legal templates for a living will. This one comes from the Pennsylvania statute. They tend, at least the ones that are contained in statutes, to be written at about a 12th grade reading level, and don't have the most accessible formatting. In almost every state, it's not necessary to use the form that's in the statute. There are other designs for living wills. I know here at Christiana that 5 wishes is used a lot, and that's an attempt to make a document that's a little more accessible to patients. The living wills don't come into effect anytime a patient loses capacity, at least living wills when they're providing instructions for life-prolonging treatments. There are usually a specific set of criteria. So for example, in Pennsylvania, they come into effect if a patient has either an end-stage medical condition, and that has a specific, relatively narrow definition in the law, or the patient is permanently unconscious. And many states have a similar set of conditions. In Delaware, the conditions are actually a little bit broader. In addition to those more standard end-stage or terminal conditions and permanently unconscious, a living will can also be in effect for a patient who's seriously ill, which is based on the healthcare practitioner's sense of their prognosis and whether they might be expected to die within the next year. So that's actually broader than in many other states. So this is a durable healthcare power of attorney. Again, this is just an example of one of the forms in the statute and what they often look like in the statute. And healthcare power of attorney, it comes into effect when a patient loses capacity. So there actually is a little bit of a difference between when a living will is in effect and a healthcare power of attorney. And if you wondered why it's called a durable healthcare power of attorney, it's not because they're written on really durable paper that's difficult to tear. It's because it remains in effect even after a patient loses capacity. Because traditionally, a financial power of attorney was only in effect while the principal had capacity. Clearly, with a healthcare power of attorney, it wouldn't be quite as useful if it lost effect when the principal lost capacity. So usually there are legal formalities that are required for these forms to be legally valid. And I'll talk in just a minute about what that means, legally valid. They vary from state to state, but usually include a requirement for a signature, probably a physical signature, and then some requirements for witnesses, and in some states a notary. There are then some other specifics within states. In Delaware, for example, the form has to be dated, and there may be requirements for who the witnesses can be. So what does it mean to say that the document is a legally valid document? Because there are plenty of documents that are used in a sense that might be called legal, and they don't have signatures, they don't follow these special formalities. In some sense, any document could be a legal document. But what that refers to is the function that an advance directive is supposed to serve, and this is usually laid out in the statute. And what the advance directive does is it imposes what might be called a carrot and stick. It imposes obligations on the treating physician. And so for the living will, if it has instructions for care that apply, the physician is supposed to follow them. There's usually an escape hatch there. The physician can transfer the patient. There's some ways not to follow it, but in general it imposes this duty. And in return, the physician has what's called a legal safe harbor, that they're not supposed to be legally liable, vulnerable to criminal prosecution or lawsuits or so forth if they're following the advance directive in good faith. So where these documents came from is they really evolved out of court decision-making on end-of-life care. And that started with courts recognizing that competent patients could decide what treatments they received. And then over time, that came to be applied to patients who didn't have capacity and the decisions that their family makers and surrogates can make. And out of that came advanced directives. And so there were a number of cases that dealt with the question of, can a patient refuse treatment? What kind of ability do they have to decide on treatments? This is one of the most well-known cases. It was from the Court of Appeals in New York just over 100 years ago. And the judge who decided it was Benjamin Cardozo, shown here. And he went on to become a very well-known U.S. Supreme Court justice. And so what happened in this case was there was a woman, Ms. Schlondorf, who had a lump in her side that was bothersome, and she was admitted to a hospital there. It was a very different time. She was there for some weeks, and really there wasn't any resolution of the issue. And then she agreed to undergo an examination under ether because she was very uncomfortable being examined while conscious. And from what she says, she told the medical team she just wanted a diagnosis. She didn't want anything done. But what did happen was the surgeon, when she was on ether, performed a hysterectomy to remove a fibroid tumor, and then she had some complications. And so she sued. And what Cardozo said, and this is quoted in many of the cases that followed, including the end-of-life cases, was every human being of adult years and sound mind has a right to determine what shall be done with his own body, and a surgeon who performs an operation without his patient's consent commits an assault for which he is liable on damages. So that line appeared in many subsequent cases. I should note that Ms. Schlondorf actually still lost the case because Cardozo also found that the hospital was protected by a doctrine of charitable immunity that made it difficult at the time to sue charitable institutions. So those cases that continued to evolve, and medicine was also, as we know, evolving at the same time and developing a greater capacity to prolong life, even in the setting of an overall poor prognosis. And so then eventually the question came up about patients who didn't have capacity. And there are a number of cases in this realm, but this is one of the most influential. It was from the New Jersey Supreme Court in 1976. And what happened was that a year earlier, an unfortunate young woman, a 21-year-old woman named Karen Ann Quinlan, consumed alcohol and Valium, went into respiratory arrest, had an anoxic brain injury, and she was kept alive on a ventilator, but her parents were told that she wasn't expected to ever regain consciousness. And when they learned that, they asked to take her off the ventilator, and the doctors and the hospital refused, so they sued. And what the New Jersey Supreme Court said was, in essence, that the patient, Ms. Quinlan, had a right to refuse treatment in this situation, that this was a constitutional right, a constitutional privacy right. And if she couldn't exercise that right, her parents could exercise it on her behalf. And after that, she was taken off the ventilator. Yes, sir. Yeah, well, that's a good question. And this, if you note the year, it was about the same time that there were other cases having to do with other issues, abortion and birth control. And the constitutional debate there had been framed in terms of privacy rights under the Due Process Clause of the U.S. Constitution. Now, you can certainly say that that's kind of a funny way to frame the source of a right to refuse treatment, but the point was there was a sort of precedent there was already established in the case law why they would look to a privacy right to say that this was a constitutional right to refuse treatment. I agree. It can seem funny in a certain way to frame it that way. So it was after these cases were developing that states started to create living will statutes. And what happened was that there were a lot of questions in these cases about the wishes of patients and how their wishes could best be followed. And so what the law did is it used the kind of tool that it often uses in this situation. And so it created a legalized process that would allow patients to document their wishes and apply certain legal formalities to try to create a way to make sure that their wishes were followed. And so this occurred in several waves. It started with living will statutes in the 1970s and 80s. And after that, durable healthcare power of attorney statutes. And then more recently, laws supporting do not resuscitate forms. I won't talk about those as much. They include the PULSE program or DMOST here, and they're kind of focused on a specific set of life-prolonging treatments and aimed at emergency medical services. So with those forms, there was a lot of variation in the types of legal formalities that were required in terms of the requirements for witnesses and notaries, whether templates had to be used, what was required to recognize advanced directives from other states, and also the criteria for when living wills are legally effective. As I just noted as an example, you can see that there is a difference, and a meaningful difference, between the conditions for a living will to be effective in Pennsylvania compared to Delaware. So going back to the living will, I sometimes hear it said that these forms, and certainly in their traditional legalized form modeled after the statute, that they're often not that useful, that they don't seem to help in many of the situations where there are important questions of goals of care and understanding a patient's wishes. And I think part of that is because they were really developed in response to cases like the Quinlan case, a case of a woman who was in a permanent vegetative state, and then the question of what should happen. But as we know, while this situation does come up, it's maybe not the most common where there are struggles over understanding patient wishes. So those are advanced directives, and now I'm going to talk a little bit about what is the evidence that they do or do not impact care. So as far as documentation, and I'm really focused here most on living wills and documentations about patient preferences, for that information to impact care, it really has to do several things. There's several things need to happen. The first is that a living will, it has to be created, or at least started. If it's not created, then it can't impact care, even if there's a way to create one. And then it has to be available at the point of care to influence decision-making. Now, certainly the process of creating an advanced directive, it could indirectly impact care. It could sort of influence how patients and families think about these decisions. But at least for the information itself, recorded in whatever form influence care, it has to be available. And then the content, it has to be helpful. It has to say something that helps with the decisions that need to be made. So first, do patients complete advanced directives? There have been a few studies to engage this question. Recently, there was a large meta-analysis by some investigators at Penn, and they looked at published literature that had reported a baseline rate of advanced directives. They included any type of advanced directive, of living will or healthcare power of attorney, and they found that overall, about just under 37% of patients had an advanced directive. more of those were healthcare power of attorneys than living wills. And so the rate of living wills was just under 30%. And interestingly, they found there didn't really seem to be a difference between healthy patients and patients who are chronically ill. Now, they did find some differences by primary disease that you can see here, with the highest rates for patients with neurologic disease and the lowest with HIV/AIDS. I mean, there's a fair amount of variability there, but you can see there are some differences. Now, our documents, if created, are they available in the electronic health record? Now, certainly there are other ways for them to be available at the point of care. I mean, a patient could have a copy on them, but the most reliable way is if they're in the electronic health record in an available format, that could make them accessible. So first, it's important to note that that question is not as clear-cut as it would seem, because there are multiple ways to be available. It could be in the chart as an unlabeled scanned document, and that might be something that can't be readily identified. Might be something that clinicians didn't even realize was there, or it could be in the chart in a structured form. It could be in a place where it was clearly labeled as an advanced directive. It could be somewhere where there's been training and staff knew to look there. So it's actually just in itself a complicated question, but however it's defined specifically, the rates are not that high. There's not great data on this, but from what I've seen between some published reports and some informal estimates I've seen based on chart reviews, is the rates might be 2 to 20% of advanced directives. So how about the impact of advanced directives once they are available? Well, there's been 3 main types of studies that have looked at this question. There have been observational studies that use electronic health record data. There's been observational studies that have used claims data linked to survey data that's designed to provide a little bit of a more nationally representative a source of data. And then there have been interventions that are designed, at least in part, to promote increased documenting of wishes. Now, I think it's important to note that it's a tough question to answer, no matter what sort of study you use, because they all face methodological challenges. I mean, not insurmountable barriers, but there are challenges. So for observational studies, there's a very significant internal validity problem. And what I mean is that inferring a causal relationship between having an advanced directive and whatever outcomes are being measured can be very difficult. It's always obviously a consideration with observational studies, but it's particularly challenging here because there are some important unmeasured confounders that may be difficult to capture. So for example, a patient's receptivity to end-of-life planning might be associated with completing an advanced directive. It might also be associated with the end-of-life care that they receive in many other ways. But where is there a measure of their receptivity to end-of-life planning? Even if there is one, it may not be very good. In the interventional studies, on the other hand, they can help overcome that problem, but they face an external validity problem that the results may be very contextual, and they may not easily generalize beyond the study to the so-called native conditions of advanced directive completion. And I'll just say, it's a note on that front, it's still the case that most advanced directives are completed in law offices with lawyers, and there's some data to support that. But as far as I'm aware, there are no interventional studies that have been delivered in law offices. So here are a few of the observational studies that have tried to address this question from different perspectives. And overall, you can see that they've generally found an association between having an advanced directive and better end-of-life care, however it was measured. So this study, Joan Tino and colleagues, they performed a national telephone survey of bereaved family members, and they looked at a number of things in the study. But one of the things that they looked at was reported advanced directives, and they found that advanced directives were associated with, and again, this per report, or more hospice use and better communication with clinicians. And then another study, just a few years later, used national survey data from the health and retirement survey that surveys individuals in an older population, and so provides some nationally representative data. And they looked at reported advanced directives and end-of-life care, and they found in general that having a living will was associated with lower odds of high-intensity care at the end of life. And then there was another study that looked at it from a sort of different perspective of geographic variation. And this study used both survey data and Medicare claims and looked at having an advanced directive, and they looked specifically most at having a living will and how that was associated with the intensity of care at the end of life. And what they found was that living wills that specified limits to life-prolonging measures were associated with lower intensity care, but specifically in regions of the country where care was high intensity overall. And that had sort of a compelling story behind it, because the idea was that in these regions where patients by default might be more likely to receive high intensity care, it was really there where having some documentation that that was not what you wanted, that could really make a difference in the care that you receive. But still, an observational design. And this just highlights one of the studies that's been done with chart review. This was done at Sloan Kettering, where they looked at oncology patients in the ICU and those with advanced directives compared to those without, and just didn't find any difference in the care that they received. So how about studies with a randomized design? Well, here you can see the picture looks very different. The findings are much less consistent in terms of whether there's a connection between an advanced directive and what happens at the end of life. And again, studies have tried to approach the question from different directions. So probably the largest of these studies came from the support trial, and that was a large Robert Wood Johnson Foundation funded study in 5 teaching hospitals in the early 1990s, and patients were randomized to usual care or a advanced care planning intervention. And that included documenting preferences for care. And indeed, most of the patients did in fact document their preferences. And overall, the study was a null study. There was essentially no impact of the intervention. And then later, there was a secondary analysis of the living wills that found that the amount of information was not usually very much in the documents, and that patients often received preferences or received care that was inconsistent with the preferences they had documented. There was a second clinical trial in a nursing home population. This was at nursing homes in Canada, and they randomized nursing homes to usual care or to an advanced directive intervention to encourage completing advanced directives. And they found that maybe there was a reduction in resource use for residents of the nursing homes with the intervention. The other outcomes they looked at, there wasn't any difference. And then there was another study that looked at the communication dimension of specifically living wills. And what they did is they showed different scenarios to patients and their chosen surrogates. And they said, imagine you were in this scenario, what kind of life prolonging measures would you want? And then they measured patient surrogate concordance, essentially to get at how accurate surrogates were at estimating patient preferences. They found that they were not very accurate in general, and then they showed some of those surrogates were actually shown living wills filled out by the patient, and they found that it being shown a living will actually did not make the surrogates more accurate at estimating the preferences they would want. It's just the information there wasn't useful enough for these specific scenarios. Now, there was a more recent study with a bit more of a positive finding, and this was a study in a inpatient setting in a hospital in Australia, where patients were randomized to usual care or an advanced care planning intervention. It was respecting choices, which is one that's sometimes used here. And as part of that, they documented their preferences. And they did find some improvement in some of the patient-centered outcomes that they looked at. So overall, most patients don't have advanced directives. Their impact on care is unclear. It's probably contextual. Where there's an impact, it may be when the documentation is bundled with more of a process of advanced care planning. So now I'm going to talk briefly about the legal model. That's the model that I described at the beginning, and what I think are some limitations in that model. And that will lead into the question of, is there some ways that this can be improved upon with technology? Well, these are the features. I won't go over them all again. We sort of discussed them at the beginning, but it's essentially a process where that's done in a law office, and it's prepared as a legal document, sort of as a will or a trust would be prepared. And these features, I think, do not always serve the purpose of these types of planning in the setting of end-of-life care. So each of these major features has some problems that it creates for the use of these documents at the end of life. The use of the templates or documents based on templates means that the content is often not useful. And the formalities present barriers to completion. And the fact that it's completed in law offices makes it very difficult to bundle with a process of advanced care planning. And the forms are rarely updated. So what I would suggest is that the process of documentation would be better to emphasize advanced care planning rather than form creation alone. In advanced care planning, it has a lot of different definitions, but it's an ongoing process, discussion and communication between loved ones, clinicians, and patients about goals, values, and preferences. And the objective of end-of-life documentation should be to promote planning and communication. Creating legal forms could certainly be a piece of that process, but should not be the overriding principal objective. So I think there are a number of possible reforms that could be suggested to make these documents, particularly for living wills, more useful. And I think in general, they would involve making the process more of a medical one and removing some of the legal formality. And now what I'm going to turn to is about technology and how that might be used in a more medicalized process of end-of-life documentation. So there are already several forms of technology out there. The now widespread use of electronic health records and the use of internet mobile technologies has brought them there. So they're here, and it's just a question of how they'll be used and what their impact is. So there are platforms that specifically will create advanced directives and in a format that can be accessible. This is just an example of one of them. This is My Directives. Now, My Directives is actually published on its user base. And this is a study of a nationally representative sample of about 900 of its users. And I'll just note here that it's overall a fairly young and healthy population. But despite being relatively young and healthy, most of the users express wishes to limit treatment measures at the end of life. So this is a website called Prepare. It was developed by a group out at UCSF, and it uses a great deal of multimedia to take users through a process of advanced care planning. There is some documentation that can be done, but it's really focused on the process of advanced care planning. And Prepare is the most well-studied of these technologies. There have been a number of published studies with Prepare, including a couple of clinical trials. There was one that was performed in a VA population with patients in primary care clinics. And they randomized patients to receive either an advanced directive or to use the Prepare website and receive the advanced directive. And they measured new documentation of advanced care planning that's in the electronic health record at 9 months. And they found that the group that had used Prepare as well as receiving the advanced directive had a higher proportion with new documentation. They also measured self-reported advanced care planning engagement and found higher levels in the Prepare arm through several follow-ups. And then there are also some platforms out there that simply serve to store documents that are created in a traditional paper form, and some of them offer the ability to transmit them to an electronic health record. As far as I'm aware, there isn't a lot of at least published study of what the impact of those might be. And I'll just make a note here about Apple Health Records. I don't know how many of you are familiar with Apple Health Records. It's a service now offered through the Apple Health app that allows users to download information from their electronic health record and consolidate it across electronic health systems. They use usually it's their patient portal credentials to authenticate themselves. And so there may be some future way here that information about end-of-life plans could be stored, although I don't think that in the kind of information that's currently pulled that usually it would end up in the app. So at Penn, we were interested in creating a web platform to document end-of-life wishes and do so in a way that really provided more useful information for families and clinicians. And so we created a web platform, and I'll talk about it a little more in a second. As part of the process, we also did a lot of user testing. There was a lot of feedback solicited from patients. And we also conducted a formal qualitative study. This is with primary care patients in 2 internal medicine clinics. And they were recruited who were, they had to be at least 70 or have 1 or more of a set of chronic diseases. And we really probed their perspectives on ways of creating advanced directives. We asked about their past experiences, and we asked what they perceived as the value of legal formalities. And then we asked them about the different ways that advanced directives could be created, and including as part of that, discussing technology, solicited their input on an older version of the platform that was developed at Penn. It's called Our Care Wishes. And then we analyzed the data for the themes that emerged. So these are the patient characteristics. It's just a note, it is by design a reasonably diverse population in terms of age, race, relatively so in education, and medical history. Now, of those patients, 11 had actually created an advanced directive, and true to the past literature, the most common way was with lawyers. Actually, 6 patients completed the documents with lawyers, either as part of an estate planning process of creating other documents like wills or alone. There were a couple of patients that obtained documents from where they received their health care. And there was actually one patient who obtained a document online, although it was more of a traditional document. a paper document that she got from an online resource. And one thing to note here is that none of the patients involved clinicians in their actual completion of the documents, even the two who obtained them from healthcare institutions, so they completed it on their own or they had family help. Now I'm going to talk about a few of the themes that emerged. I'm not going to go over all the results because I want to leave time to talk about ARCare Wishes in its current form and some of the ongoing work. But I think there are a few that are worth highlighting. So the first is that patients very consistently value legal requirements. They might have not seemed that useful to me when I was writing about it, but patients had a different perspective. And what really came out is that they have a lot of concerns that their wishes will not be respected by clinicians. And they have the feeling that if they have something that has the imprimatur of the law on it, that is a legally formalized document, that clinicians will be more likely to take that seriously. Another theme that emerged is that patients would like a lot more input from clinicians. So even the patients who had used lawyers to create documents commented they really would have liked to be able to talk to someone who could tell them more about the terms and could answer questions and maybe even apply it to their personal health situation. And then there were a lot of concerns about creating documents online and about the potential risk their information, because it is very personal information. And I think, as a note here that it may be that as we saw, many of the users of these online services are younger and healthy, and it may be that there are certain populations, and I'm speculating here, but are more comfortable using it than others. And a question may be about how comfort overlaps with the populations that most need these kinds of end-of-life planning and would benefit from it the most. Here in this sample, which tended to be older and more chronically ill, there were quite a number of concerns. But it was also noted that their concerns were at least partially allayed by having a resource that was connected to where they received their care. In this case, that was Penn. And that was because they're used to Penn managing their personal health information. And so it's less of a leap if it's a website associated with Penn that then is going to be managing this information about their personal end-of-life wishes. So this is the current version of ARCare Wishes. It's still a work in progress. This is the current version that's live. You can look it up on a phone or laptop. Just note, it was created by the Center for Healthcare Innovation at Penn. And the Palliative and Advanced Illness Research Center leads a lot of the research with the platform. So just a few notes about some of the features and the design. So patients can apply legal formalities to their document. They can download it, do that, and upload it and store it. But they don't have to. It's optional depending on how much a patient values having those legal formalities. So the content is designed to take them through a process of completing the different parts of the website. So it's designed to be sort of guided, in that sense, linear, but also flexible. Patients can choose to complete just the parts that they prefer to complete. And there's an effort to elicit more information than is typically in a living will. And so, for example, it will ask them about their quality of life and what are the things that really matter to them in terms of feeling like they had quality of life in a seriously ill state. And there continue to be efforts to revise and develop this content further. And it does allow a user to transmit their document directly to the Penn electronic health record. They use their Penn patient portal credentials to authenticate themselves. And it also is designed in different ways to use behavioral economic techniques to promote sharing and dissemination. It does that in some ways with surrogates, and I won't discuss as much, but it does it with EHR integration. And so after patients create a document, they're presented with the option of sending it to their chart. They don't have to, but it presents them with the option, at least forces them to make more of a kind of balanced choice. And that's in contrast with what would normally happen with advanced directive, and that's unless a patient created it in a health system and there was specifically a workflow to get it into the electronic health record, the document wouldn't necessarily get there. If they complete it with a lawyer, it might not, go within miles of their electronic health record. It would really be up to them to make a special effort. So this is designed to create greater symmetry between the choice to add it or not. So returning to some of the barriers to advanced directive effectiveness, here's how Our Care Wishes is designed, and it's still being evaluated, but it's designed to overcome some of these barriers. So as far as completion, it's available online. It's free of charge to people to use, and it's designed to sort of guide patients through the process. And it does have a connection to the health system, at least right now, to the Penn health system. It could be a different health system, but just designed to make them feel like this website may be a reliable steward of their data. And of course, there is an effort to be responsible stewards of patient data. And as discussed, it's designed to make it much easier to get it into the electronic health record. And then the content is designed to be more detailed and more useful in a way that hopefully can do a better job of informing treatment decisions. So this is a trial that we currently have underway. It's recruiting now, so I fortunately don't quite yet have results to share. But this is in an outpatient setting with patients in a GI and thoracic malignancy population. And they're being randomized to receive either Our Care Wishes, and that is to be shown it and encouraged to use it, or a paper advanced directive. This is one that's often used at Penn. And we're measuring new advanced care planning documentation in the electronic health record. The primary outcome is any new documentation at 8 weeks after enrollment. We're also measuring some outcomes that elicit more of a patient perspective, looking at change in satisfaction with end-of-life plans, with advanced directive acceptability, and we're also soliciting qualitative feedback that I think will provide a lot of useful information. I'll also note that there's also another trial that a palliative care physician at Penn is leading that's going to look at Our Care Wishes in an inpatient setting as well, and that will be starting shortly. So I want to close just by talking about what I see as the major unanswered questions around the use of this technology. So going just back to now to the study that I just described. So our endpoint is advanced care planning documentation, and we've already seen that there's at least one technology out there, an advanced care planning web tool that at least in some settings seems to increase advanced care planning documentation. But this is a process outcome. What we really want to know is what is the impact at the end of life? Does going through this process online, even if it does make the documentation more available, assuming it does it affect what happens to patients in terms of their acute care utilization, to the patient experience, symptom management, and the family and caregiver experience? And if it does it work in certain populations? What are the ways that can make it most effective? And so those are the questions that need to be addressed going forward. There are also some policy questions. There's some legal questions about trying to formalize one of these advanced directives online. I won't go into some of just the nitty-gritty of those legal questions. I'll just note it's a little unclear if you could sign one electronically. Probably not. It's a little ambiguous. But then there's a policy question of should you be able to? Now, I'll note that there has been an effort in one state, in Maryland, to take a step in trying to promote electronic advance directives. They've actually modified their statute, and they allow electronic signing of advance directives. They have certain criteria for how the patient has to authenticate themselves. And they have a program to recognize vendors of online advance directives that meet those requirements and to take some steps to promote their use, to incorporate them into the health information exchange and so forth. So to wrap up, as I tried to discuss, these documents really evolved as legal documents in response to some legal issues that have been encountered in cases. And in general, they're not often completed. Their impact is unclear. And we don't yet know how technology will impact end-of-life care, how these tools might best be used, and what their impact will be. But there's a lot of work ongoing. And the law, in any case, as it often does, lags behind the technology. And so I'll stop there. I'll be happy to take any questions.
Thank you for that nice summary of something that's been evolving over 40 years. Two questions about Our Care Wishes. How does EMS connect to that? Do they have access to it? Or, I mean, if somebody in Philadelphia calls 911 and EMS shows up at their door, how do they look at Our Care Wishes? And the second question is, how does that system interface with POLST? Is POLST a part of Our Care Wishes? How does that connect?
Great. So good question. So the first question was, how does EMS access Our Care Wishes? And the second was, what about POLST? Does Our Care Wishes interface with POLST? And the short answer to both questions is it wasn't really framed as a yes or no question, but is no, in the sense that I mean, there isn't a formal mechanism for EMS to access the website. Certainly, if a patient had completed a document, I mean, they might have it, they might be able to try to show it to them on their phones. I mean, it sort of in general makes it more accessible. It's a bit tricky with EMS and their ability to follow living wills, which is part of the reason that the DNR forms like the POLST forms now exist. There isn't a capacity to store a POLST form. It only stores documents that are created on the website, although I guess as it develops, I mean, in theory, you could probably upload something else, but it's really focused more on living wills right now and more on providing kind of richer content for end-of-life decision-making and doesn't yet incorporate more in the DNR form realm.
Hi, thank you. That was a great talk. I have two questions. One is related to the issue of electronic signatures and how that issue is handled for patients or people who actually cannot physically sign their own signature because of disability or paralysis or something like that. And so the idea of preference versus ability in that sort of legal discussion. And then the second question goes to your research design for your current ongoing study. I noticed that when you discuss the outcomes related to advanced directives, patients with cancer, their outcomes actually were unchanged based on their advanced directives in your review of the literature, at least in one of the studies. It was the oncology patients. And my question is, are you planning or did you have wrapped into your current study, along with the GI and thoracic oncology patients, sort of another control group that might allow you to assess any confounders related to patient relationships with their practitioners, their level of disease and acuity?
Great. So the questions were first about legally signing documents when you're unable to sign them, and the second question was about use of the cancer population and whether we consider it in the ongoing study and whether we considered having another group as a control, and then more generally about sort of the contextual factors there. So as far as the first question, I mean, some of that is state law driven. I think that in general, there are a lot of the sort of ways of signing it are, it also depends on which document you're talking about, but they're a little more flexible than they seem. So in terms of what kind of someone just truly had no way of kind of affixing any kind of physical mark, whether they could have someone complete it on their behalf. Usually that's actually a good question. And it may be that there's some cases on this, and, you know, some, as I said, is state-based. I mean, usually someone, unlike a form like a pulse form can be completed by a surrogate. Usually a living will is specific to a principal. And as I said, generally it'd be fairly flexible in terms of how you would indicate making a mark. But if you really just had no way of doing it, that's a good question. I'll get back to you on that. And then in terms of our design, I think you bring up very good points, and this is one of the challenges, is that the impact, I think, is very contextual, and so it can depend very much on the population being studied and what's already happening in part of usual care. So you can imagine if you had just even the same population also in oncology clinics, but there was already a really developed initiative to get care planning documentation, electronic health record, you might see a very different result from a clinic where there wasn't any of that. In this case, we chose it as a starting point because we felt there was a need, and we actually wanted to hold the population constant, so at least that wouldn't be a varying factor in terms of comparing the advanced directive to the electronic platform.
Great talk. Two questions as well. So the first, we asked questions by the twos here, Joshua, if you haven't figured that out. The first is you make a very compelling argument for moving away from thinking about advanced directives and as, you know, filling out a form and instead making part of advanced care planning. As we think about these web-based tools or our care plan, which the name of the product at Penn on which you're working, can you comment a bit about the computerized decision support for the patient? Right, so in real life, when we're doing advanced care planning, there's a lot of back and forth that I might envision feeds into the patient's decision-making as to what they want to do for advanced directives. How does that work, one? And two, are there literature that exists that show that there are some components that are core necessities if you're doing this via the web, for instance, and not in front of an attorney or a doctor, that promotes a patient doing their advanced directives? The second question is about where the discussions can take place. So your hypothesis, it sounds like, is that it's better to not have these discussions frequently take place in law offices, or at a minimum have what's in the law offices happen within the, you know, translated to the hospital environment. Does where you have that discussion surrounding advanced care planning influence completion of advanced directives? And is there a difference in the kind of type of provider who may be having that discussion sort of at the index of the discussion with the likelihood of someone completing their advanced directives?
Great. And so just to summarize, the first question was about sort of the computer decision support that was available. And the second was about the ways that sort of discussions are had as part of completing documents and whether sort of those maybe provider and clinic characteristics matter. Yeah. So, and more great and not that easy to answer questions, but as far as the first one, it's in terms of the support right now. There is someone available who you can contact to receive input. There isn't well, there is some computerized support in sort of design, which takes you through the different parts of the website. There are kind of some nudges that are built in. I mentioned one of them. There certainly is a lot more potential computerized decision support that could be built in. I think that is one of the theoretical advantages of a technology platform, and then you could even imagine that it could try to in some way use the patient's health information. I mean, the form might have different content for someone from a neurologic disease population versus, let's say, a cardiac population. I mean, so those are certainly ideas that we have to build in the content in the future. Right now, it's really just sort of taking the guidance, taking through parts, the nudges, and then you can contact someone, ask a question. And in terms of the second question, I know there's been some literature on the stability of preferences, which I think at least gets a part of it, although not certainly all. And I think the general finding is preferences are somewhat stable, but not completely stable. I mean, certainly my intuition is that some of those details would certainly matter, both in terms of the timing, in terms of where you are relative to acute illness or your medical history, and then in terms of who is helping you and how, and just many factors. And again, it's sort of the challenge of the contextuality of it, and how you sort of reach generalizable conclusions about how those things might matter. And so I think in a lot of those cases, it requires a lot of kind of testing, and for health systems requires a lot of careful evaluation within the context of their own health system and the specific question related to that general issue that they're trying to address.
Quick question on the quality of life section on the Penn platform. I have an inherent bias against checkboxes and yes/no questions. So I'm just curious if there's a narrative basis to quality of life on that section.
Great. So the question was about the quality of life section, and about if there's a way to provide more sort of a narrative answer rather than a checkbox answer. And I certainly hear your point, because these preferences are not, it's not like answering, a board exam question where, well, is it D or is it C? So the way it's structured right now, it is the main questions are, they do have fixed answer choices in terms of patient preferences. There is the ability at the bottom of each section to add anything that you would like related to that section. So you could certainly add quite a bit of detail there.
Are these questions sort of like HR questions? Existing surveys?
It's sort of a combination. So some of it comes from reviewing some of the other resources that are out there. Some of it, such as in the quality of life section, it comes from some prior work that had been done at Penn on asking those types of questions. Some of it is just from our sort of view and trying to frame the questions to be better. I think in general, as far as that question of how things are framed, there's not a lot of research out there and kind of well validating certain framings. And I think that is one potential issue we're interested in looking at going forward. I should note one other purpose of Our Care Wishes I didn't really talk about as much is it also is designed as a research platform, because you can actually create studies with different designs and configurations. So it also can be used to address that type of question specifically, as far as one formulation is better than another in terms of whatever measure you define.
So thank you very much. I think we are going to stop here because the room is needed. But thank you again, and